Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law, LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring with a background that includes both legal work and hands-on business roles. I'm Lisa Mosbey, and today we're talking about seller financing, earnouts, and holdbacks in business sales and how these structures help shape what each side is actually agreeing to beyond the purchase price. Mark, this is a very detailed podcast today. I'm looking forward to getting into this conversation with you.
Great to see you, Lisa.
In business sales or with many business sales, the purchase price isn't paid entirely at closing. How do seller financing, earnouts, and holdbacks actually fit into this overall deal structure?
Probably helps to just give it a quick example, and we'll use $1 million purchase price on just to make the math easier. But so the seller financing might be that a seller is looking to maximize dollars from the transaction. The buyer may not be able to access credit through an SBA loan or otherwise. And the seller is willing to take the risk of a default on seller financing, which is basically just a loan from the seller that says, all right, look, you're going to buy this business for $1 million. We're going to document it through an asset purchase agreement, which is typical. There can be stock purchases or membership interest purchases in an LLC, but we're going to document through an asset purchase agreement, and you're going to pay me $300,000 in cash at closing, and then you're gonna sign a $700,000 promissory note, and then that will be payable over X number of months or years, with a rate of interest on it typically, and under IRS rules, you need to actually have an interest rate on it, what's called the applicable federal rate, but and that would be your seller financing, and there may be some lien rights and some recapture of the business in the event that there's a default on that promissory note. The promissory note is just a loan, and then you've got earnouts, which are maybe we'll get into a little more detail, but the earnout would generically just be a situation where the buyer doesn't pay 100% of the purchase price, so they pay $700,000 in a non-finance owner finance situation in cash, and then they hold back $300,000, and it's based upon that the business over the next 12 months is going to be assisted by the seller as a consultant or employee of the business, the new business owner. And if the business performs as it had historically, then the seller gets the rest of the money, because the buyer really doesn't have as much knowledge or visibility on how that business is going to operate. The seller does, and the seller's willing to take that risk. And then the last one deals more with like indemnities, where you've got a holdback, and then it's kind of like an earnout, but if something goes wrong or an asset or a contract doesn't get renewed, then maybe the full purchase price doesn't get paid because the full value of the business wasn't transferred when the closing occurred because of this subsequent contingent event that negatively impacted the business.
Those are great brief overviews, and I tracked with you quite a bit, but I want to go a little bit deeper on these. Now, earnouts are often used to bridge gaps in expectations. What are earnouts designed to accomplish, and where do they tend to create friction between the parties?
Obviously, if in the perfect world for a seller, they're going to get 100% of the money at the closing table, and they walk away into the sunset. They would love to, and some people want to stay on. I mean, I've got some clients who have been working for the people that bought their company for 5 years afterward, because they're getting paid well and they're an integral part of that new business. But the typical small business owner, in particular, one who's looking to retire, they would like to get out of the business as quickly as possible. But the buyer has risk in making sure that there's continuity of that business. There's a lot of relationships that let's say it's some 30-year industry mom and pop, where mom and pop know all the customers. Mom and pop know all the suppliers. And you want to be able to buy that business and make sure that it's not just them handing you the keys and maybe a vendor and customer list, but the relationships continue. And so the buyer is going to sit there and say, hey, look, I'm willing to buy this business. And I've taken a look at your past financials. They seem to be, well, and I mentioned triangulating in on value and making sure you validate businesses where you look at bank records, you look at deposits, you look at profit and loss, and you look at tax returns, and that you can helps you vector in on the history of the company. And then, history passes prologue. So history, you then project through a pro forma what you think you can earn this, and then hopefully you're going to be a better business operator than the seller. That's the goal, is buy it and improve it, or through growth typically, but maybe some operational efficiencies. And you're going to tell that seller, hey, look, I need you for a year, and I need to put you on payroll or as a consultant, and you're going to do X, Y, and Z for me for the year as part of the deal. And there may be some compensation associated with that, but ultimately there's also, let's say in this scenario, $300,000 held back on an earnout. And that's a little different than the holdback combines with the earnout typically, but there's just not the full purchase price paid. And then there may be a revenue benchmark that says, hey, look, you made, I'm paying you $1 million for this business because you had $1 million of revenue. And then there's a profit margin associated with that. So I'm valuing the business at 1 times revenue. Well, if the business only does $800,000 the next year, and it isn't maybe the fault of the buyer, which there may be some conditions in the asset purchase agreement, then the buyer is only going to be willing to pay $800,000 for the business, and of that earnout, only $100,000 goes to the seller at the end of those 12 months, based upon the conditions that were negotiated in the asset purchase agreement. And that seller may make $100,000 as a consultant working full time for that next year, so that's somewhat of an offset. But time is money. So anyway, long story short, the earnout, and that's a very simplified way of putting it. But they're super complex ways of doing it depending on the sophistication of the business. But it's essentially just, hey, I'm buying the business, and we believe everything's good and stable and going to continue, but we need to see evidence of that. And in particular, with these mom and pop relationships, you really do have to be worried about what happens when they go away. Does the business die? And you don't want to buy a business like that because, like my business would be very difficult to sell. People hire me. They don't, I can't go and get some 25-year-old lawyer that's got 0 years of experience versus my 30 years of experience and say, by the way, I've got all this work in process, hundreds of thousands of dollars of billables, and I've just sold it to this kid. Keep working with him at the same rates. And people, the clients are going to say, well, are you kidding me? I'm hiring you. Well, it's the same kind of thing for, a mom and pop, blue collar, or restaurant type business or whatever else. There's relationships there.
Mark, you mentioned that oftentimes holdbacks are linked together with earnouts, but are there other structures of holdbacks that are typically used?
Within an asset purchase agreement, we've just talked about like the earnout, right? So that is a bucket of money. There's some amount of money that wasn't paid based upon the purchase price that is to be delayed based upon some performance benchmark for the company. Well, within that asset purchase agreement, there's also what are called representations and warranties and disclosure schedules. And so to the extent that some condition doesn't happen, and it could be going back to the example of a significant contract. Like I have a client right now who has a deal that he's trying to sell a company, and he's got a series of customer contracts, one of which matures in the next few months, and it's about 35% of the total revenue of the business. Well, he still wants to sell, the buyer wants to buy, and then there is a holdback on that contract where if it doesn't renew, it is going to impact the earnings, which may impact the earnout component, but it's going to be a permanent impairment to the business going forward as well, in which case maybe there should be an appropriate reduction in the purchase price through the holdback. And the holdback is the actual bucket of money that's held back. Now, whether that money may be held on the balance sheet of the buyer and it's just commingled with their funds, or it may be escrow. Like if you're concerned about, hey, look, this is a significant amount of money, and I want to make sure if I satisfy as a seller, whatever the conditions are, the money is there and there isn't some, liquidity problem with the buyer, especially if they're rolling up a bunch of companies. You want to make sure that there's money sitting there for you. Now, if the buyer has to park money in escrow, that costs them money because maybe they borrowed that money through their capital structure of the company. So escrowing is better for the seller because then there's money sitting there. And as long as they satisfy the conditions of that release of that holdback through either an earnout or the renewal of that contract or just other conditions that would trigger the release of the holdback, then all of those funds do go to the buyer subject to satisfying the conditions for the release to the buyer. And these adjustments happen all the time, and they're at the discretion. It's two people's opinion as to what took place, and so you want to really narrow down and try to figure what the actual result is. But where profit or revenue is the determining factor on the release of those funds, who has control over that better, the seller or the buyer? Well, the buyer does because the buyer's now operating the company, and the seller's the one waiting for the money. So it puts the buyer in a stronger position, and they can be I've got situations where we're going through accountings and hiring forensic accountants and fighting over significant amounts of money based upon a dispute, and ultimately it'll get resolved, but it's expensive. So, again, cash on the barrelhead, 100% payout and walking away into the sunset, that's a seller advantage. And for the reverse is true for the buyer. So these are all buyer protections.
And I can see how that would be difficult. Most people aren't going to come in with cash. Like you said, mom and pops, you don't know what you're walking into and if clients are going to stay with you or shift over. So I see how these tools are used a lot in managing risk, both for the buyer and the seller. But these structures depend heavily on what happens after closing. So what tends to create disputes when expectations or results don't line up?
Usually they're anticipated as to what the conditions are. So then it's just what causes it? Well, something didn't go right that's anticipated. If it's a revenue benchmark, the revenue wasn't there. Well, okay, then under the agreement, who has responsibility for that? If there is, quote, no responsibility for it, and it's just a straight up, hey, I'm willing to buy this business that did $1 million a year every year for the past 5 years. It was very consistent, no growth, just made that much money in revenue every year. And I will only pay $1 million for it if it achieves $1 million. That's a simple, earnout. And if it's 800,000, then it's a dollar for dollar reduction. Well, that's super simple. Question is who had responsibility for that reduction? Who was it? A loss of a contract, or was it just poor management by the buyer? Did the owner stay on and was supposed to assist with producing revenue and managing expenses, and then there was a problem there? Usually the agreements don't get into the nitty-gritty of who's at fault. It's just proof is in the pudding. Either the business did $1 million in revenue or it didn't, or the business has a 30% profit margin, so it did $300,000 in profit, or it didn't. And so reduction in revenue, that hurts profit. Addition of expense, that hurts profit. So those are usually the pretty clear things. But then there can be defaults on like, hey, look, you didn't disclose a particular risk under the asset purchase agreement. Therefore, you have liability up to a cap of the holdback amount. Let's say, again, $300,000 is held back. Doesn't have to do with earnings. This could be a risk to the business that wasn't disclosed and accepted by the buyer. And so if they discover something, be it, lawsuit, patent a patent that was supposed to be transferred, or copyright, that something was not true in those representations and warranties of the asset purchase agreement, then there could be damages associated with that. And if it's fraud, there may be unlimited damages. So, yeah, you sold the business for $1 million, got $700,000. There was a $300,000 holdback, but oh my God, the entire business failed as a result of this fraud or lack of lack of disclosure. And not only does the seller not get the $300,000 based upon the buyer being angry, and rightfully so, the buyer may sue the seller for that fraud and either try to tender the entire business back and get his money back, or sue for damages. And so, the damages can't exceed a holdback amount. It's not like you get off scot-free in a lot of instances, albeit, I always try to cap exposure for my seller clients, and for my buyer clients, I try to broaden the exposure to the seller because I'm representing the whichever party I'm representing. I'm trying to advantage them as much as I can professionally within the situation.
Other areas that come to mind that I think of disputes arising are, we couldn't plan for COVID. Most of us couldn't plan for tariffs or changing economic times. There's only so much that these tools can do within a deal structure, but there's all these outliers that can affect those things. And we can't always agree to that up front because we don't know what's coming. Wouldn't you agree?
Yeah, I mean, although there's what's called a force majeure provision in a lot of contracts, and there may be that in an asset purchase agreement, but usually it's not the case. I mean, or not, it's not hotly negotiated. There may be a boilerplate force majeure provision, and no one had a COVID pandemic provision in their force majeure provision until 2020, and then all of a sudden, every lease and every contract started adding it. That said, these exogenous events are just outside outlier things. A meteor comes in and destroys the world. Okay, great. There's an old saying of a guy that was, Wall Street guy, where he was like, hey, look, if there's nuclear weapons are thought to be soon flying, he's like, buy everything, because either it's not going to matter, or you're going to be the one that, when they call off the nuclear attack, you're going to be the one that's long the stock market, and the market's going to go up because of the fear has gone away. So it's a similar kind of thing with these deals, to where if you have some exogenous event that you can't prepare for, well, that's a deal risk of the buyer, typically. Albeit if there is just a straight up clean and easy revenue benchmark for an earnout or a holdback or whatever it might be, it doesn't matter why the revenue wasn't hit if there are no conditions on why the revenue wasn't hit. And so those are points of contention on, hey, look, I'm willing to take this risk as a seller, and I'm going to actually work hard for you, and I'm going to take some exogenous COVID meteorite, flood risk that's associated with this business, in order to facilitate the transaction and help get the buyer comfortable, that you're in bed together, and you're actually going to have a common outcome, to where there is some, risk on either side, and that's appropriate. So documenting all this stuff, I mean, you can't plan for everything, but, you can de-risk it and put some shared exposure, which, is healthy in a lot of senses, to keep people honest.
Well said. And I think we'll leave it there today. Thank you for walking us through these complicated legal strategies in structuring deals. It all matters, but we as lay people don't necessarily know. So we appreciate your expertise.
Thank you.
And that's it for today's episode of Atlanta Business and Commercial Real Estate Law Podcast. If you're structuring a business sale and considering options like seller financing, earnouts, or holdbacks, you can visit battlesonlaw.com to connect with Mark. Thank you so much for listening. Be sure to like, subscribe, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.